This is the first of two lectures on sales and use tax nexus. The first lecture covers the basics. The second lecture covers the special issue of nexus in clicks and mortar groups. Those are corporate groups where one corporation operates stores in a state and an affiliated online corporation operates an online store. The objectives of this lecture are to understand the general requirements for sales and use tax nexus in a state, to understand the special rules that require a seller that has registered with the Streamlined Sales and Use Tax Agreement, the SUTA, to collect tax in all SUTA member states. Let's first examine the basic nexus requirements. A state can impose its tax laws on a seller only if that seller has substantial nexus in the state. This prohibition stems from the U.S. Constitution, which is federal law and overrides all state law. Prior to the 2018 Wayfair case, the 1992 case, Quill versus North Dakota, said that a seller has nexus in a state for use tax purposes only if the seller has physical presence in the state. I emphasize that this case deals with use tax. It applies also to sales tax if the matter should ever come up, but since sales tax ordinarily applies only to an in-state seller, the matter of nexus in the state is ordinarily irrelevant. Quill versus North Dakota required physical presence for there to be nexus. Physical presence exists if either the seller or the seller's agent has physical presence in the state. While it may seem simple to determine if either the seller or the seller's agent is physically present in a state, this is not the case, as we will see in the next set of slides. Physical presence, especially where online companies are concerned, can be quite difficult to determine. Under the nexus rules after Wayfair, physical presence in a state can still result in nexus. Wayfair did not take this rule away. However, physical presence is not required. That is, Wayfair simply took away the protection that the physical presence requirement gave to remote sellers. Wayfair establishes a new economic nexus test based on economic activity in a state. In Wayfair, South Dakota found nexus if the seller had $100,000 of sales or 200 transactions in the state. The economic nexus rule will apply to many sellers, since $100,000 of sales or 200 transactions in a state is a relatively low threshold. For smaller sellers, prior state standards, which ordinarily took into account physical presence, may continue to apply. Therefore, it is important to understand both the economic nexus rule and the nature of physical presence. While physical presence is not an absolute requirement for nexus, physical presence can cause an out-of-state seller to have nexus. Physical presence will likely be an important factor in determining whether smaller sellers have nexus. How difficult can it be to determine if a seller or its agent has physical presence in a state? Very difficult. Here are some of the issues we face. Is the intermittent presence of employees or agents in a state sufficient to cause nexus? Examples are presence at a trade show and service calls to customers. Whether nexus results depends entirely on the facts. For example, Webco has its offices and personnel only in Oregon. Company personnel attend a trade show in State A where they maintain a display booth for 10 days. Does presence at the trade show constitute physical presence in State A that will result in substantial nexus? There's no way to know for certain. The answer will depend on whether State A decides to assert nexus. If the state decides to assert nexus, then the taxpayer may have to acquiesce to the state in order to avoid going to court. If the taxpayer decides to go to court to fight the state, then the matter will depend on whether the court agrees with State A or the taxpayer based on the facts. Another physical presence question is, does the taxpayer's equipment in a state, such as a web server, cause nexus? The answer to this question depends entirely on the state. For example, Webco has offices, personnel, and most of its equipment in Oregon. However, it uses a web server located in State B. Does the presence of a web server in State B constitute physical presence, resulting in nexus? The answer depends on two things. First, much will depend on whether the server is controlled by the taxpayer, such as where the taxpayer owns or leases the server. In this case, many states take the position that the server constitutes physical presence and substantial nexus. On the other hand, if the server is controlled by an unrelated person that merely hosts the taxpayer's website, most states will not assert nexus. Some states will totally ignore the presence of a web server in the state. Others may aggressively assert nexus, even where the server is controlled by an unrelated hosting company. In this area, there's a vast divergence of opinion. Does software licensed to customers in a state cause nexus? It can. As discussed in the text, an out-of-state company licensed software to customers in Texas, and the state asserted nexus based only on the presence of the software. Does an employee or agent working out of his or her home in a state cause nexus in the state? It can. Some states will assert nexus while others will not. Much may depend on what the person is doing in the state. Sales representatives in a state, for example, may be more likely to result in nexus than, for example, computer programmers working out of their homes. Does the presence of a company's intangibles in a state result in nexus? Nexus can result from the use of intangibles in a state. Does the presence of affiliate program members in a state result in nexus? A strong case can be made that the presence in a state of numerous members of a taxpayer's affiliate program can result in nexus. So far, this type of case has not been widely pursued by states. However, many states have enacted statutes under which there is a rebuttable presumption that affiliate program members in a state cause nexus. Does the presence of a related company doing business in a state result in nexus? The presence of a related company doing business in a state does not by itself result in nexus. However, if that company acts as the agent of the taxpayer, then nexus can result. This issue is discussed in depth in the lecture on clicks and mortar groups. If a supplier in a state drop ships a product to a seller's customer in the same state, does nexus result? Ordinarily, a drop shipment does not cause the seller to have nexus, but the state can require the drop shipper to collect the tax. Does the performance of computer warranty services in a state performed by a third-party service provider result in seller nexus? Nexus can result, but the determination depends on the relationship of the person performing the services to the seller. The primary question is whether the service provider acts as the agent of the seller. Sometimes this will be the case, such as where the customer acquires a service warranty directly from the seller. On the other hand, if the customer acquires a service warranty from the manufacturer, not the seller, then the service provider may be acting on behalf of the manufacturer, not the seller, in which case the activities of the service provider are not performed on behalf of the seller, and the seller nexus does not result. Under Wayfair, an out-of-state seller can have nexus in a state and can be required to collect tax in a state even if it does not have physical presence. However, it must at a minimum have economic presence. The most important thing about the Wayfair case is that it emphatically revoked the physical presence test, which had stood for nearly 50 years, originally expounded in Bellis Hess and later affirmed by Quill versus North Dakota. So under Wayfair, physical presence is not a federal requirement for nexus. Some states may continue to require physical presence, but federal law does not require them to do so. What is required for nexus? Wayfair did not say. The case did not invalidate any prior nexus rules other than the physical presence requirement, but neither did it create specific nexus rules. While the court in Wayfair did not say what constitutes nexus, it did say that there must be some connection with a state before a remote seller has nexus. It did not expound on that connection, but it did say that South Dakota's test, $100,000 of sales or 200 transactions, was sufficient for nexus to exist. Since Wayfair, a number of tests have adopted rules identical or similar to the South Dakota rule, which we are describing as an economic nexus rule. 3 factors were highlighted by the court in Wayfair in its ruling in favor of the South Dakota economic nexus rule. The economic activity in a state had to be substantial, and the court ruled that South Dakota's requirement of $100,000 in sales or 200 transactions in a year described activity in the state that was sufficiently substantial to cause nexus. The South Dakota rule was prospective, not retroactive, so that application of the rule was fair to remote sellers. South Dakota was a member of the streamlined sales and use tax agreement, which results in simpler tax compliance for remote sellers and a lower burden on the seller in collecting tax. Many states that are members of the SUTA have enacted new statutes that mirror those of South Dakota. Presumably, those statutes should withstand judicial challenge. Other states have adopted economic nexus rules that partially mirror those of South Dakota. It is unclear whether the laws of those states, especially those that are not SUTA members, will withstand challenge. The final issue in this discussion of nexus basics has to do with the streamlined sales and use tax agreement, or the SUTA. Where a seller is registered with the SUTA, then the seller must collect tax in all SUTA member states. Registration with the SUTA is voluntary. Thus, for sellers who are registered with the SUTA, substantial nexus is not required as a condition for collecting tax in a SUTA member state. The state can require the seller to collect tax regardless of the seller's presence in the state. On the other hand, a seller that is registered with the SUTA is not required to collect tax in states that are not SUTA members unless the seller has substantial nexus in the non-member states.